to tell me that we set the base and then move forward. So we understood what mediation is about a little bit, and we're still getting to learn it in detail, but we understood some principles of mediation, what it is, a third party helping people communicate with each other and try to find a solution to a conflict they could be experiencing, a dispute they could be experiencing. Of course, we learned what a dispute and conflict is, went on to that. After that, we learned about the stages of mediation. The first being opening, introductions. The second being communication. Third is negotiation. And the fourth one is settlement. And we've covered 2 stages so far, that is of introduction and communication. And today we will be looking at negotiation. Negotiation here, Nalini, you can play it. So negotiation here in mediation is slightly different from the negotiation that we talk about in terms of we negotiating with somebody else. 2 parties negotiating is one part. In mediation, it's a facilitated negotiation. So the mediator helps parties talk to each other. Next slide. So introductions, communication, exploration, negotiation, problem solving, and agreement and closure. So what we are looking at this stage is a problem solving. Parties have come to you with a problem. What you've done is you've gone through a stage where you've heard them in the introductions, in the communication. You've also reached a point where you have re-established communication if it was broken down. So negotiations generally begin only after parties are actually facing each other and talking to each other. They're cordial to each other. They're listening to each other. Till such time, you are still exploring how to establish that communication. And don't worry, it happens all the time. In some cases, it takes longer. In some cases, it takes lesser time. In business disputes, it's much quicker. In personal disputes, it can even take months for that real communication to establish. But once that happens, and once you realize, and I always use these words, you notice a shift. You notice a shift in a body language. You notice a shift in the way they look at each other. You notice a shift in the way they talk to each other. Sometimes there's a smile. Sometimes they laugh at a joke. It's different things in different cases, but be aware. Notice those little changes, and you'll know that now is the time for you to use negotiation techniques and try and bring them towards solving the problem together. Because in mediation, the parties solve their own problem. We only facilitate it. So when we think of negotiation, we think of something like this, like a tug of war. I lose, if you win, I lose. If I win, you lose. So that's the kind of idea that we always go with, saying that particularly when there is compensation involved, some kind of claim involved, we go with the attitude that if I have to win, you have to lose some. So that's the approach. In mediation, we look at a slightly different approach. We try to see what is it that matters to you and what is it that matters to the other person, and is there a way where both can go back with something. Many times this communication becomes very difficult because both parties get stuck on what we call as positions. You have to pay me compensation. When you're talking to the person you are angry with, it's very hard to have a conversation beyond that. There are threats, there is anger, there is frustration that's shown, but you can't go beyond that because the person you are addressing is also reacting, because the blame game is going on. A third party helps to diffuse that tension and helps you to communicate in a structured manner. So remember one thing, throughout the process, mediator, even though the parties are talking to each other, to a certain extent, the mediator is facilitating it and controlling what exactly is that negotiation that's going on, the communication that's going on. I want your comments on this. Do you think it's possible to convince your dispute, the party you are having a dispute with, through argument? You must have had several in your lives, and with family, with siblings, with your friends, with your colleagues. If you take a stand upon something and you start keeping on defending your stand, is it really possible to go ahead when your whole approach is that of argument? Remember the word argument. That's what we lawyers do in court. We put up a case. We don't listen to, we are not interested in the other side. We are interested in how we are right and how they are wrong. And that approach rarely gets you anywhere. But we are trained to be, we are trained like that. That's the approach that we have been trained in. That's what we feel that is the right way to enforce our rights, to basically get what we want. And the mediator has to understand this and understand that parties will behave in this manner and still try and get them to negotiate with each other. Right? Anyone has a comment? Next slide. So, negotiation is a dialogue aimed to reach an agreement. Before we go ahead in what and how it's to be done, let's understand the term dialogue. Dialogue is basically done in a collaborative manner. In fact, William Isaacs is the author of the book Dialogue and the Art of Thinking Together. And he describes dialogue as two people thinking together. And that's exactly what we aim to do in mediation. For that, the primary thing is that both people have to see the problem in the same way. Why don't we have a dialogue generally when we are talking to people? When we feel that something has gone wrong, or I am right and someone else is wrong, why can't we have a dialogue?
Our perspectives are different.
Yes, Deepa, I can't hear you. Sorry.
Our perspectives are different.
Our perspectives are different. Absolutely right. Do you want to elaborate a little bit on that?
See, it is like there is a particular incident that has happened. Now, if I was doing it and you were at the receiving end, you would have a very different feeling than what I would have had we interchanged our places. So that is perspective. So we will not be able to have a dialogue, because at some point of time you may have something to tell me where I've gone wrong, and I might feel that was the best thing that I did.
Absolutely. So in mediation, how we define this is the definition of the problem. When the problem is defined from the point of view of one person, it's difficult to have both sides contribute. So one of the jobs that the mediator does is to define the problem in a way that both see it as a problem. And we will have exercises with respect to this in terms of our role play. But keep it in mind that a dialogue is only possible when your goal is common. Most people who have come to you in a mediation will have very literally contrasting goals. But you have to find that, you have to understand the problem, and that's your job. That's your literally your primary job, of understanding the problem and making both of them see the problem as a common problem. And this is literally the crux, just like you did the reframing exercises, where you remove the emotion out of a particular sentence, you looked at it from a future perspective, you change that sentence to diffuse the tension. In the same way, we look at problems in a way and we try to make it a common problem for both parties. Okay, next slide. This will, of course, we will be working on this in terms of an exercise, and therefore we then eventually a dialogue is possible. Both parties look at a common problem and are in a position to think together. Unlike how we frame issues in a matter, we tend to look at it from a perspective that is so and so right or wrong. This happened. Was there negligence or no? Was there a breach of contract or no? That's how we want to explore things in that manner. But in mediation, we explore solutions. We explore what can happen in the future and how a particular issue is a problem to both parties. And that's when parties are in a position to look at it from a perspective. Okay, let's work on this. This sounds like a problem that both of us have. What are our options? Next slide. So negotiation is a to and fro communication with a desire to achieve a goal. All negotiations involve an exchange of value. The focus is on creating value by defining a term offered rather than rejecting it outright. It is different from bargaining, where each side only wants economic benefit. And I'm going to put a caveat out here before I proceed. Mediations are done in different types of cases. There are cases which are complex, such as long-term conflicts, which involve a long-term relationship. And then there are short transactional matters, which are primarily related to a one-off transaction, maybe primarily economic in nature. When it is an economic transaction or a very one-time issue, there is mostly a bargaining. So bargaining also happens in mediation. But when we are learning the art of mediation, we are looking at more complex matters where we can really add value to the solution that we reach. And that is mostly in disputes that have gone on for longer, or between parties where the relationship is very important to the parties. And the matter is complex in terms of various layers of the dispute itself. In such matters, value may not always be economic in nature. For example, a matter such as an inheritance case. There are two siblings. The siblings value the relationship as much as they value the economic aspects of what is distributed in the will. However, because they feel that they have been wronged, or the will is unfair, or the distribution is unfair, the focus on that transaction has a negative effect on their relationship. The idea is to break that down and try and establish that communication in such a way that they see that the will is one thing, but is there a better way of doing it? Is there a way where we can satisfy the needs of both the parties in this transaction because we value the relationship. And to see that if we don't do this, then it will affect the relationship. The matter may go to court. It will be very hard to resolve. That being done without actually giving a sermon. It has to come from the realization of the parties through communication and through negotiation. Does that make sense? Yeah, Dr. Preeti, you have a question?
I agree with you on that, but sometimes you have two parties coming in where one knows very clearly, for example, now this inheritance thing that you came up. So the will has said that one person is going to get everything, the second guy doesn't get anything. So he knows he has an upper hand, and he's not really coming with anything on table because he knows that he's getting everything. So that kind of a situation, I think, would be more difficult because he already has everything in his bag, as they say, and you're trying to get the second party at least a piece of the pie, kind of a thing. So does that
Correct.
also happen?
Absolutely correct. But the bottom line is both parties have agreed to mediate.
Okay.
So that's one signal that they value the relationship. Okay. Secondly, when it comes to the law, now in such cases, there will be a lawyer involved. Because if it is so blatantly unfair, there will be a way that they will be protected under the law.
Right.
And the idea is to do it through mediation because of the confidentiality and to protect the fact that you don't want to wash this dirty linen in public. If you take this matter to court, the same thing will happen in court, but it will be very public.
Right.
And the way it is done in court in the adversarial fashion is that there will be a lot of blame game and it won't be diffused. The tension will keep growing because you'll have multiple applications being put, you'll have exposure of the finances, you'll have a lot of these arguments that go back and forth, which will make it harder for parties to reconcile. Whereas people have now come to the understanding that if the same thing is done behind closed, even if somebody says, you kind of manipulated the father to sign this will, and says it behind closed doors, but as against saying it in an open courtroom and making an application and writing that down in your petition, that impact is much higher.
Okay.
And very difficult to reconcile when such statements, because then you realize that sometimes these cases come at that stage back to mediation.
Okay.
And then you realize that more than the property and anything else, what has hurt is the fact that that statement was made in the petition. This is very common also in matrimonial cases.
Okay.
Because the kind of grounds that you need to take to win in the court are quite hurtful. But you have to do it because there's no other way out of a litigation. And when that happens and you then go to mediation, it's a little difficult because you see that has hurt. And if that keeps on continuing, the distance keeps growing. But if they come to mediation before, which is what is happening now, slowly, people have started looking at mediation as an option before you send a legal notice. And not just people send an invite to mediate, I'm seeing more and more people accepting it. And then looking at it from the point of view, let's do it behind closed doors. Let's talk. It's impossible to talk to each other. Maybe a third person can help us communicate. And that works. So that is what we do. And this also case I'm talking about from personal experience that I've seen such cases. And just like you're saying, there was resistance from one side to come to the table. And there is, obviously the other side wants it, but they do come because somewhere they value the relationship. They also understand the effects of if this matter is filed in the court. And there's also the legal research that one needs to do to understand how it can be challenged legally, the will itself. So there are various strategies that need to be adopted by which you bring the person to the table and kind of what we call it in mediation is have a power balance.
So we come, I mean, as a mediator, you come into play only if both come to the table, or do
Yes,
you also have a
yes.
role? Do you also
No.
have a role in trying to get the second party in? Do
Very
you get it?
rarely, the only thing that we do maximum is send an invitation letter saying that
Okay.
so-and-so has approached us.
Okay.
But we, regarding a dispute that they are facing with you,
Mhm.
and we invite you to participate in the mediation. That's
Okay.
what we do, but that also not as an individual mediator, as a as an institute.
Okay. Got
As
it.
a
Got it.
mediator, I wouldn't, because I wouldn't get involved in the facts till both parties approach me,
Correct. Got
to
it.
keep
Got
that
it.
neutrality.
Got it.
And even if somebody does, I'll generally send them to a lawyer and say, I'm a mediator. You go to your lawyer, you find out everything. And if you feel a mediation is possible, then you can come to me.
Okay.
And you can't come to me alone. All of you have to come to me. So first take an agreement with your, with the other party that you all want to mediate, and then you all can appoint me. So that's the process. And if you all want this to be made, it is easier, go to an institute. So that's the process.
Okay. Thank you, ma'am.
Yes, Dr. Deepa, thank you. Yes, Dr. Deepa.
I wanted to know what you said. I missed your word when you said that you can use it. One of the points of how you can go to approach the court. You said that term in the last part of what you said. Can you come again? When we were talking about the will which can be challenged and the way it can be challenged in the court, then would that not amount to manipulating the sides?
Challenge. I don't know what word I use. Anybody else remembers what Dr.
Very
Deepa?
sorry then. Very sorry then. You use some
I'm sorry.
technical term.
Okay. Mrinalini, Kamakshi, do you all remember what was the word I used? We'll come back to you, Dr. Deepa.
Yeah.
Yes, ma'am. Thank you.
And yes, you said will not that amount to manipulating the parties? So remember one thing, that, like I explained to you later, you can refer the parties to a lawyer to find out what what are their options, because many times this is a situation which Dr. Preeti spoke about, where there's power imbalance, because one of the parties has really no power because the will is one-sided in that sense. So in that case, to be able to negotiate with the other party, there might be some action required. That's not an action that the mediator advises, but it's an action that the mediator can tell them, please refer to your lawyer and see that they, you create some, see what advice you are given as far as challenging the will is concerned, and you can then look at mediation if that's a possibility, if they are not agreeing straightforward to talk about it.
Thank you, ma'am.
Yeah, next slide. So why do we negotiate? To achieve a goal, to avoid exploitation, and to cooperate with the other side. Okay, so if we don't have a space to negotiate, it's basically like in this case, there is a transaction and it's one-sided. If I am quite averse to going to court, it's going to cost me a lot of money. It's going to, it's going to be hard, and but I have a goal to achieve. How do I do it? One of the ways is to explore, to negotiate, and if you follow the process correctly and you have a good neutral, you will get an opportunity to be able to negotiate and establish a power balance through various methods that we can do that, and also cooperate and try and do it in a manner that helps you retain that relationship if the relationship matters to you. Next slide. The basic criteria in negotiation It should produce a wise agreement. It should be efficient, and it should improve or not damage the relationship between the parties. If we follow the process the way it's designed, and we are careful about the way we communicate, I can tell you that the third point is almost a given. That whatever is the state of the relationship that parties have come to the table, irrespective of whether they have reached a settlement or not, definitely there is an improvement in the kind of communication they're having with each other rather than what they came to the table. This is my personal experience. And that's all about following the process the way it's defined. We have to aim that the process is efficient. And at the end of it, it should, that's the ultimate goal, of course, that it should produce an agreement that is wise, that works for both, and not one-sided or not something that looks, that looks unfair or where one goes back miffed. It's important that it's balanced, and that we use our creativity to do that, not ours, but we encourage the parties to be more creative and find a solution. Next slide. What is our role? We facilitate as mediators. So obviously, this is a session where we are looking at all of us as mediators and not as the parties who are in dispute. So that's one thing that we have to be very clear about, that all of you, I know, have come here with an intention that how will you resolve disputes that come, that you all face either as an institution or as a individual. But it's important that the way that we are learning the process is that you are not involved personally in that dispute. You are a third party who is facilitating. And that's a very, very important aspect of mediation. It cannot be done by an interested party. We will have a session on neutrality tomorrow, and you'll understand what it is and why it's important. And also, I think Dr. Preeti had asked this question right in the beginning, that how do you stay neutral? Is it really possible? So that's something that we will look at tomorrow. We have a guest speaker who's coming to address that. But in a mediation, you are always a neutral. You can't be a mediator in your own case. You can use some of the techniques, you can use some listening skills, you can use some skills, but if you are mediating a dispute, you should be completely neutral in that matter. What do we do as facilitators? We facilitate dialogue. We enable parties to build a working relationship to resolve their disputes. We get parties to recognize and work towards fulfilling their interests, generate options to solve the problem, recognize the possibility of an impasse, and aid parties to make reasoned decisions to reach a settlement resolution. So let's look at the words that we are looking at here. Resolve their issues, fulfilling their interests, solve the problem, recognize the possibility of an impasse, and make reasoned decisions and reach a solution. All of these things we need to facilitate, because parties don't come prepared with this. Okay? So for that, of course, we need to understand what each of these things are. So let's do that. Next slide. Also, we move the discussions from positions to interests. So we will first understand what are positions and what are interests. Maintaining momentum towards exploring solutions. So one of the things that you will find very often, expect it and don't get intimidated by it, is the fact that you will get stuck. You'll keep going round in circles. You know, the same argument will keep coming up and it will be very, very frustrating, because there's something that has not happened for the parties, that they have either felt heard or they felt that that point has been noted or not noted by the person, or it's something that's deeply traumatic for the person. It's something where that point will keep coming up and you'll go in circles. You have to recognize it and use one of the tools to try and move from there. Otherwise, you will feel that we have reached. Don't confuse an impasse with failure. Impasse is a temporary spot where you are stuck, which you can use tools to move forward. Failure, where there's absolutely no solution possible. We will see impasse in several stages during the mediation. In fact, you will see it right in the beginning during the introduction. It will look impossible. But understand that it's impasse. It happens in every case, and that is why they've come to a mediation. If they were able to negotiate with each other, why would you be needed? You are needed because somewhere they are stuck in their communication. So assure yourself that this is normal, this is going to happen. What are my tools? What can I use to be able to move forward? So that is called maintaining momentum, because it's quite normal in a mediation that you get stuck on one point or one aspect, or things escalate. Be an observer and understand when you need to step into de-escalate and move. Idea is to keep moving ahead through those stages. Encourage parties to generate options to resolve the conflict and restore power balance. So we spoke a little bit about power balance. But power balance is restored in many ways. Sometimes power as such, one needs to understand, comes in various forms. Sometimes it's an authority. You know, you hold a position, in a position like you are, you're a police officer, or you hold a position because you are highly educated, you're a doctor, you're a lawyer. So there's a certain amount of intimidation that comes with that kind of a position, or knowledge. Then there is political power. There is tremendous power in money and resources that you have. You own a large business, and then somebody else comes in who doesn't have that power, comes from a different strata, or comes from a different position, either of knowledge, either of chair, or money, or even a relationship. If there has been an abusive relationship, for the victim of an abusive relationship or the survivor of an abusive relationship to negotiate with the abuser, it's intimidating. To recognize that this exists is very important for the mediator, because there is tremendous power imbalance there. And whether it's a good idea to do it, or whether this needs to be decided by a judge, or you need to have some way where they are not, they are not face to face till you restore the power for the individual who doesn't have it. That exploration is really important, so that you don't put the parties in a spot. You will know when you're a mediator and you hear parties talking to each other, you will know that here this is not power balanced. This person is intimidated to say something. One typical example is when your father is in the room. Inheritance matter. You want to say something and your father is in the room, but your culture is such that you are not in a position to speak in front of the father. But you've got massive issues which you want to talk about. but he is in the room and you've never spoken, you've never looked him in the eye and had an argument with him, but you want to say certain things. How do you restore that balance? How do you make that possible? So sometimes one needs to do it, it's not necessary to argue, but you can do it respectfully, and to give them that space to be able to do it, that it's okay, and to prepare the other party also to be able to listen. That's our job. And but it starts with understanding where the issue is, where the balance of power is missing, and how it can be restored. Is always through communication, but it's also by using a joint session and private session. It's also by using reframing techniques, where you remove the blame, you put it out in a particular manner, and you encourage people to be vulnerable wherever is possible, and to build that connection. So these are some of the things that we focus on during the session. Next slide. Before we go here, any questions on the slides prior to this?
I can't speak for the others, but this thing is sounding so difficult. I tell you, the way you are putting it across. I don't know whether it's really, I mean, it's very, I think, intuitive also. I think when you do
Yeah, it
many of
is. Yeah.
them, yeah, when you do it, I think you know which direction to head. Right now, it's so theoretical. I think unless you actually really
Yes.
face it, you
Yes.
really wouldn't know.
I think passively we have to absorb at this stage,
Yeah.
and maybe
Yes.
whenever the situation arises, we have to remember
Yeah.
what Kanda said or what JP
Yeah.
said, or
Yeah. Yeah. Hats
Um,
off. Hats off.
so as much as it sounds complex, the process is designed in such a manner that you will get the time to absorb these things. The whole idea is to hold our judgment for as long as we can, and to have the intention we should have is to establish communication and let them find their solution. If we go with the attitude that I will find the solution, and I listen
Can't hear you.
to the facts and kind of put the puzzle. Can I be heard?
No, the last part we
Okay.
couldn't hear.
From when you were explaining about the last bit, I think we lost you there, but then now you're audible.
Okay, so what I was saying is that don't go in with the aspect that I will fit in the puzzle. Just be open to understand the people involved and the problem, both. And that is when all this will come to you, that okay, this is not a there's a power imbalance here, there is there are deeper issues here, let me explore it. Also using a little bit of discretion in terms of what questions should I ask in a joint session and what questions should I ask in a private session, so that you don't expose somebody to something, and to also empower them to understand that they don't need to say something if they don't feel like saying it in a joint session. So it's it's the use of all of these things that it's not as hard as it sounds right now, because this is something that we are discussing for the first time. It does. We'll of course do a role play, and as Dr. Subodh said, that once you are faced with that situation and with practice, it's something that comes much easier. Yes, Roshali.
So this restoring power balance, the typical example that you gave, I'm sure there would be many more, but to my mind, getting into caucus is one way of it, but that may not be the 100% foolproof. Then how do you manage it otherwise?
So we have several. We have reality checks. So reality check is basically trying to find out where you actually stand in the matter, because somewhere you might come with a attitude that I will win this because I have, this is my case, these are my documents, and so and so. But basically, both parties will come with their lawyer, and there might be things that you can challenge in that matter. So it's for both parties to explore where they stand and whether they really have the power. And remember, one thing is possible that there is no power also in some cases. But let the parties be aware of that instead of taking it in court and then, going ahead and messing it up. And I've seen those kind of cases also, where there was one case. It was very strange that it didn't get settled. This was a case where there was a contractor who had done this massive project for a builder, and there was a large transaction, and the builder, according to his calculations, paid it off. But the claim of the contractor was much larger. And how it was larger is that he was to get a percentage, as it's always is, of the material cost. That was their understanding. And he was somebody who did the cement work, the wood work, and some other that kind of thing. And the glass work was not included. Glass work was done by somebody else. And the glass was directly procured by the builder from someone else. But this person had given the measurements and things because it had to be fit in with his work, scope of work. So there was an overlap of scope of work, but the glass was separate. And there was no specific agreement to this effect, but it was an understanding, and quite a clear understanding as far as that transaction was concerned. But the contractor had a claim that he will, he deserves to get that percentage on the entire contract, including the cost of the glass, which was literally doubling the whole thing, the cost of the project. And the builder was quite clear that this is not what he is interested in, and he cannot negotiate. He said, because he's come to mediation, I'll give him an amount to settle this, because I don't want to go to court. But I don't want, obviously, it's out of the scope of work that he's asking this money for. Now, when that happened, one of the things that we did is try to do a reality check. And we explained this to the contractor through his lawyer, that this is where you stand. In fact, the lawyer was very clear that if we go to court, we are not going to get anything. But the contractor still decided to go ahead with the court case. So this will happen. It's not for you to get the ultimate settlement. It's for you to point out. Now, if they are unable to see it, that this is a waste of, I'm wasting good money after bad, and I'm going to keep on going to court and spending money, but eventually get nothing out of it. In fact, might have to pay damages to the builder because of this, frivolous litigation that I've gone through. I've made them go through, but they will still choose. And that's okay. It's not, you've done your bit in terms of giving them, a complete understanding. So I've seen this in a couple of cases where people decide to go ahead with a litigation despite having clarity in terms of there's no use in going for litigation. That happens. But in most cases, moment they see it, they realize it, and they come with a proposal and they say, no, let's settle this. This is fine. There's no way. I'm okay with. And the settlement amount then is far more reasonable. There is a, that it looks doable. But one thing also an observation that despite all this, the parties still go back talking to each other. And that itself is the achievement of the mediator, that they were able to actually talk to each other and say, "ठीक है, यहाँ settlement नहीं हुआ, I'll go back to court, but I understand that you have a point of view." So that is the number one achievement for the mediator. And to realize that at the end of it, it is their case. Sometimes it will settle, sometimes it will not. Sometimes it will look so obvious to you, but they will not buy it. And that's okay.
So do you have lawyers instigating their parties not to move ahead with this? I mean, I'm sure there might be some, at least theoretically, from where I see. Do they? Are they usually
Lawyers,
always supportive? Yeah.
my now we all, it's literally a judgment that we are with which we are passing. If you're, so basically that's the judgment, but I'll tell you from my personal experience, and I've been doing this for the last 10 years. 95% of the lawyers I've worked with have been extremely cooperative, and I can go to the extent of saying that we have reached a settlement in cases only because lawyers were involved. If it wasn't for the lawyers, it would have been very tough. So that's my personal experience. Yes, there have been some cases where lawyers have played it very hard in terms of what they want. And sometimes they have had the other side concede and get what they want. At times that has led to, the matter dragging. But I can't say that there have been cases where lawyers have actually been responsible for the final decision. It's always the decision of the parties. But they know that, this is how much I can stretch it and I can come to a settlement or not. There have been those 5% cases where I thought the lawyers were not very cooperative. But then there were equal number of cases where I found that the parties were not very cooperative also. So we cannot judge just lawyers, and I would consider them extremely friends for in most mediations rather than foes.
Thank you.
Thank you. So we have different types of negotiation, and we use all types when it comes to mediation. There is hard and soft, where we say that in negotiation, we are hard on the problem and soft on the people. So we don't have judgment on the people in the mediation. We understand them. We understand where they're coming from. And but we actually face the problem and really try to resolve it. There's positional. So we'll get to what a position is. Position is the stand that you take when you come to a case, like what you want, the immediate thing that you want. So I want compensation is a position. So there is negotiation that's positional, which is basically just saying that you have to pay me so much, and the other person saying, no, I'm not going to compensate for this. So if you don't move beyond that stand, that initial step that you take, that's called positional negotiation. There's distributive, where you have a pie and you distribute it. You're saying, okay, 50 lakh rupees is the damages. I'll give you a portion of it and you bear the rest of it. So that kind of distribution is distributive negotiation. Then there's interest-based, which is, we'll first understand what interest means, and then understand what interest-based negotiation is, and integrative or principled negotiation. So basically, interest-based and integrative and principled negotiation is what we try to focus on in mediation. The first three we use, but we use more of the last two, and we'll look at what that means in the next slides. So soft negotiation is where we avoid conflict. We trust others. We believe they are friends. We change positions easily and make offers. We concede generously, avoid contests of will, make concessions of the relationship, back down to ultimatums. So it's typically a case where either the relationship is very, very important to you, or the case is very, very important to you. You have extremely low power balance. So your power in that negotiation power is very less, because either you value the relationship more, or you have realized that there is very little power that you have in that matter. Hard or competitive, win at all costs, adversarial in nature, you distrust other people, you dig into positions and make threats, win contests of will, demand concessions to have a relationship, make threats and ultimatums. This is where you don't value the relationship as much. Winning is more important to you than the relationship, and also where you know that you have more power in the case, in terms of maybe your legal rights, in terms of other forms of power that we discussed. Principled negotiation is where we try to solve the problem. So we look at the problem and we try to look at be generated to explore interests. People and know each other's sides and best walk away alternative. So all of this we are going to look at. So it's not that I can explain it to you in a sentence. We are looking at each of these separately and trying to figure, trying to explain each of these points separately. Next slide, Mrinalini. Yes, Sunu?
Where is the interest based in that comparison that you did? You did hard, soft, and principle, right?
Yeah. So
And
no,
you said we
so-
follow more of the interest based and the integrated principle one.
yeah, no, I didn't say that. So basically, we follow the last two, the interest-based and integrated or principle, and they are they are the same in terms of how we proceed on them.
Okay.
Okay, so when you look at interest-based, it's called interest-based, principled, or integrated. All of them come under the same category.
Okay. So this hard and soft and positional, you don't do much of.
So all kinds of negotiations are used depending on the situation. As I told you, some matters are simply transactional, and then you do positional because there's no interest to be explored. So I think it will be more clear when we understand what positions and interests are and how we are talking about them, how to explore them. There are times we'll just be at the surface, you've taken a bank loan. I'll give you a simple example. You've taken a bank loan and there's been a default. The bank has certain criteria. There's no relationship other than the bank loan or the bank account that you have with that bank. When they ask you for the money, they are interested in getting the money back. What will they do? They'll say, okay, we can forego so much interest, you pay immediately. So the entire thing will be on the basis of that, how much time do I get to pay and how much money do I pay? You will bargain with them that I'm not in a position to pay this much. You have charged excessive interest. I'll pay you this much, whatever is the amount, and I can pay you in 3 months. So you also have a little scope of doing that, but that's it. There's nothing else. There's no relationship that you are exploring. There's nothing else that you can give them. You've already defaulted on one loan. What else will you do for them? Maybe you can say that my sister will invest with you or things like that. But generally when this comes, there are all so many different units that for that transaction, it's completely transactional. There you will have position because you're only exploring one aspect and there's not much to explore beneath it. But there are other cases where you, like we talked about the inheritance case. We can talk about matrimonial cases. We can talk about a doctor-patient relationship, where there are various levels of emotion and things that have happened and things that can happen in the future, which will be material to that resolution that is reached. Then what happens? Then you can't go just on the basis of that amount of money or anything like that. Okay. JP, would you like?
Yes, Ganda, thank you so much. You know, I'll take all of you a little back. Ganda told you every negotiation involves an exchange of value. Now, what do we understand by value of a commodity? What kind of values? See, every commodity depends on its utility, right? So there can be two kinds of utility of a commodity. One is use value and other is exchange value. Now, let me give this to you with an example. What is the use value of water?
Quench thirst.
Is that all?
To clean, purify.
How much, I mean, you're all doctors, how much of body mass is water?
70%.
70%.
Can you live without water?
No.
So use value of water is immense. But now let's look at what is the exchange value of water. Can you exchange water for anything?
No.
It all depends. I mean, if you're in a desert, yes, you can bargain water for something else. But ordinarily, we cannot think of any, exchange value of water. But now let me give the example of diamond. What is the use value of diamond?
Ornament.
Yes. Anything else?
Investment.
It's like money. Like, I mean, that's all. I mean, you can use diamonds in your, as you said, for ornament. Or maybe like one, I mean, another use that I can think of is for cutting glass. Diamonds are used for purpose of cutting glass. And or some minute part in some machinery, like, in some watches. But otherwise, you can barely think of what use, a diamond can be put to. But when we talk of exchange value of diamond, depending on the size of the diamond or value of the diamond, you can exchange it for almost everything. So now, why am I telling you this? Is because, let me give this in a practical example. Let's say I go to court and I get a decree. I mean, ultimately, if you go to court or a consumer court or anywhere, what will you get? An order of the court? What is the use value of that order or the decree?
Let's
Right.
No, if you can execute, they say, like, the main
Execute.
problem, your problems start when you want to execute a decree. I mean, the real problems start when you want to execute the decree. The data may be gone. There may be no assets available. So it's in that sense, I mean, it's good. It's like an ornament. You have a decree, you feel very happy. But when it comes to use value of that decree, there are now some, asset reconstruction companies which buy those decrees for 20%, 30% of value. Otherwise, the decree is like a diamond. But when it comes to the real money or resolution of a dispute, like, for example, filing a suit for recovery, when the matter gets settled and you get money, as we said, we talked about that bird in hand. That money has value today. I give you that example of that MSCT case where the woman, 10 lakhs today had more value than 20 lakhs after 7 years. That's value. So in negotiation, there's a slight difference between negotiation and bargaining. What we do in a, marketplace is bargaining. Bargaining is primarily relating to exchange of price or an economic advantage. Everyone tries to get the best deal. So what you're looking in a bargaining is basically an economic advantage. But when it comes to negotiation, you can add value, and every negotiation will have an exchange of value. And that is why negotiation, why do negotiations happen? For two reasons. One, something which you can't do on your own. If you want to sell your ware, you need a buyer. Otherwise, you can't sell. And the second use of negotiation is to resolve a problem. If there is a problem, the only way you can negotiate is by you can decide or remove that dispute or a problem is by negotiation. Because in negotiation, we add value. Now, how do you add value in negotiation? Now, let me give you an example. When you go to court or when a parties file a suit for, let's say, a suit for recovery, the only thing that you can get in court is either your suit is decreed or your suit will be dismissed. There can't be a third other option. But when you negotiate, you can look at the money being paid in installments. You can look at part money being paid and the remaining paid with interest. You can look at, for example, a buyer-seller dispute. You can, have an agreement that whatever goods, the money that I have to pay you, you supply me goods in future and I will add some amount to the price, and that money you keep deducting. So you can get your money over a period of time, and plus the relationship of buyer-seller will continue. All this happens through negotiation because you have agreed to negotiate and add value. They say when you bargain, you are actually wanting to distribute a fixed pie. You see, like just now, Ganda told you about positional bargaining. If I have 100 rupees to distribute, we can have 40-60, we can have 50-50, when we can have 30-70. This is called distributive bargaining or distributive negotiation. And Distributive negotiation is positional bargaining where the sum total of negotiation is zero. So one person's gain will be another person's loss. So if it is 50-50, it is 40-60, then the person who got 60 gained 10%, the person who got 40 lost 10%. So net result is zero. It's called zero-sum game. This is what negotiation is. Negotiation will expand the pie. It expands the pie. It makes the example of, you've already done that about the water bottle and the water, or the orange example, where both the daughters got what they wanted. So it was 100% became 200%. You enlarge the pie. That is what negotiation does. Because Ganda used two words, positions and interests. Because once you reach the interests, you're able to find solutions which enlarge the pie. Now, every negotiation, please remember, has 7 elements. Now, first important thing in negotiation is preparing for negotiation. You do not enter a negotiation room or sit on the negotiation table without preparing yourself. And to prepare yourself, you need to remember there are 7 elements which you need to work on. Let's see the next one. Next slide. I remember my school days, I used to hate history because I could not mug. And our teacher used to say, history, geography, badi bewafa, raat ko padi subah safa. And therefore, most of the things I would remember by acronyms. So now we've given you an acronym to the 7 elements. We call it rainbow elements of negotiation. It is the acronym is CRYOLAC, CERELAC. So you'll remember this word, CRYOLAC. Now, C, the first C stands for communication. As I told you, when people are in conflict, when people are facing problems, the first thing that breaks down is communication. People stop talking to each other. How do you solve problems? Ganda told you a simple definition of negotiation: to and fro communication with the desire to reach a goal. The goal could be, dissolution of partnership. Goal could be dissolving the marriage. Goal could be finding a solution to where should we go for lunch. And therefore, for purposes of finding a solution, we need to communicate. And for communication, what do we need? We told you, we've done chapters on communication. You need active listening. You need clarifying and probing skills. You need questioning skills, which we talked about. And by doing that, what do? You establish communication between the parties of what had already broken down. So the first thing to remember when you sit in negotiation is to ensure, because what happens when parties come in on the negotiation table in mediation, they will talk through you. They will not talk directly to each other. They will not even look at each other. They will talk through the mediator. They will complain to you. This is what that person did. Instead of looking at the other person, they will keep telling you. Now, what is your role? By using those communication skills which we've talked about, is to establish direct communication between the parties so that they start talking to each other about the problem. That's the first thing that you need to do when you're negotiating, that communication should be established between the parties. Now, second, R, CRYOLAC, relationship. See, a good relationship is required to address the differences and conflicts. We need to separate people issues from substantive issues. And we have to plan to build a good relationship. You see, unless parties are having a good relationship, where do you think the negotiation is going to happen? Where do you feel that the problem is going to be solved? If we are not even willing to sit on the same table, talk to each other. I told you when we lay down the ground rules in the beginning, that when one talks, the other will listen. We have already started the exchange of ideas for purpose of resolution. Parties have already started to concede space. And that can only happen when you have good relationship. You see, otherwise, why do we lay down that ground rule? When one talks, the other must listen. We should not talk over each other. Because whenever communication starts in mediation, since parties are so full of venom against each other, they will not let the other person speak. They would not like to listen to the other person. Because with every sentence the other person utters, there will be reaction from the other side. So we need to establish relationship in case if problems need to be resolved. So first important thing, we must establish communication, then work at establishing relationship between the parties. We need to be respectful, ask the parties to be respectful. And that's the only way. That's why we lay down the ground rule. Now see the importance of that ground rule. We will not use language which is inappropriate or which hurts. All this will fall in place, whatever we did in the past. Now let's look at the next one. Interests. You see, positions are the stand parties take. I want this. I want the orange. Till you ask the question, why do you want the orange? You don't reach the interests of the parties, the needs of the parties. Why does the girl want the orange? And therefore, unless we reach interests, because positions are the tips of the iceberg, we need to find out what do people really want. If you remember, I told you while questioning skills, first thing when a person takes a position, your question should be what is important to you. And once he says, look, this is what I want, the next question is, why is it important to you? These are questions which take people from their positions to the interests. They say interests are the real movers behind why people take positions. People take positions because of these interests. I want this because of this reason. So you have to reach that reason. Remember that partners dispute? I want to leave. So it was a wise partner. The senior partner was very wise. He said, why do you want to leave? So this is where you need to first remember that we need to identify the interests, because this is where you will find sometimes conflicting interests. Sometimes you will find common interests. And sometimes those differing interests are the reason why parties negotiate and settle. See, let me give you this example of two people want to play a tennis match. What is the common interest between these two?
Tennis.
Tennis. Both want to play. What are the differing interests?
To win.
To win. And that is why a match will happen. Unless the interest to win is there, there will be no match. Unless both are interested in playing tennis, there will be no match. So we need differing interests as well as common interests. Shoe seller wants to sell his shoe. Common interest is shoe. The buyer wants it at the minimum price. The seller wants at the maximum price. But what does happen here? You see, in this particular instance, the interest in the shoe for the buyer is more than the money that he has, because he really wants the shoe. While for the seller, money has more value than the shoe. He wants the money. And this is where in negotiation, once you identify interest, remember this word, trade-offs happen. And these trade-offs are, I will give up something which has less value for me for something which has more value for me. Similarly, the other person will give up something which has less value for him for something which has more value for him. And mostly when we have differing interests, whatever he wants to give up, maybe I have more value. So I'm willing to concede. And that is why settlements happen. Because for me, something may have less value. For the other person, that may have more value. You know, we look at matrimonial disputes. For someone, custody-related issues may have more value for them. For some, maintenance issue may be more valuable. So person may be interested in giving up more visitation to the other parent for the money that he can get. So when these trade-offs happen, then only negotiation takes place and settlements happen. And that is where this will only happen if you reach the real interests. And that is where your communication skills will come in. So communication, relationship, interest. O, options. Options are pieces of agreement or agreement. What kind of agreements can happen? As I told you in that example of money dispute, suit for recovery. Options generated, I'll supply you more goods in future and you can keep deducting money from the sale price. The money which you have to pay me, you can keep deducting more money from that. Or I'll give you extra money with each good supplied. These are options. Some money can be paid upfront, some money can be paid to me in future to me. Those monies which come in future may come in installments with interest. You may give me a security to secure my money so that I don't have to come back to the court in future. These are all options. These are possible areas of agreement that can happen. And they always say, don't start negotiation with one option on the table. Have multiple options on the table. Which will work, we don't know. But when you start negotiation, ask parties, what will work for you? The question to ask, again, communication skills, asking questions, what will work for you? Help me understand what will work for you. Parties will give you these options. You need to only keep prodding them. You know, in a partition suit where brothers have 50-50% share in a property, the property is only 50 square yards or 100 square yards, and you can't divide it 50-50 because municipal laws don't permit it. So what can happen? A decree is passed, the judge decides both the brothers have 50-50% share. Ultimately, in court, generally, that property is put to sale, and the sale consideration is divided 50-50 between the brothers, because that property can't be divided because municipal laws don't permit it. Subdivision of plots or smaller plots. But what can you do in mediation or negotiation? You can go to a builder, rebuild the whole property. Each person can have a full floor on each floor. And one floor you can give it to the builder. So you have a new building, you have a new floor, 100%, 100 square yards, full floor available to to both the brothers. And the third floor goes to the builder. These options, these value addition can only happen in negotiation. So what do? In every negotiation, we look at communication. We look at establishing relationships so that parties open up. They discuss their options and interests. We look at interests of the parties by asking why questions, what questions. We look at options by asking what will work for you. Correct? Let's see the next one. Legitimacy. See, legitimacy is what criteria will work for both of us so that we don't both feel cheated. Now, how will that happen? You see, as I told you, I have a plot, a corner plot, which has been very lucky for me. It's a 200-yard plot. The market value of that plot is 1 crore. But what happens? Since it's been a lucky plot for me, I insist on selling it only for 1 crore 25 lakhs. And I don't get a buyer. Or there's somebody, a buyer likes the place, but he's not willing to pay 1 crore 25 lakhs because he says the market value is 1 crore. Now, what is the way to find out what is the real value so that the buyer doesn't feel that he's been ripped off his money and the seller also doesn't feel cheated? So what is that legitimate standard that we will look for? Anyone?
There are these reckoners available. I mean, I don't know the name for it, but then each area has its own property value based on.
Those are called actually the rates which are prescribed by the government. See, but those rates are really not the market value.
Right.
Yeah.
You know, so though what do you do? Go to the sub-registrar office, find out in that locality last 6 months how much the properties have been sold for. Go to a property broker.
Okay.
Find out how many properties have been sold in the last few months and for how much. See, those are standards which are not based on what I want and what you want. So they are not based on the will of either side, but that's a fair standard which we look for by going to the market, going to a valuer, going to a property broker, going to a builder, anybody whom we trust. So legitimacy is outside my will, outside the will of either party. We apply this standard. You see, sometimes parties get stuck on positions. You know, I am entitled to this much. You know, sometimes let's say again a matrimonial dispute. Party says I'm entitled to like 2/3 of his salary. Now, what do you do? How do you test legitimacy? You can tell, have you discussed it with a lawyer? Have you seen what is the latest position of law? How do you empower parties so that, you know, they can feel when the final settlement happens, that settlement is fair. This is what is called legitimacy. So therefore, the settlement must be fair, not what you want, not what I say. Let's apply an independent standard. So we need to, in every negotiation, look at communication, look at relationship, building relationship, look at the interests, look at options, possible options that can be generated, more than one, and legitimacy. After this, what do we look at? Next one. Alternatives. Now, alternative is what will I do if we do not reach a settlement? And this is a question most mediators do not ask, most negotiators do not ask or answer. If I don't reach an agreement, what is the option left for me? What is the alternative? Where do I go? And mostly, you know, this alternative is judged by the only option is if we don't settle, we go to court. And if we go to court, what is being offered to me? Now, like, look at the example of those two brothers. If they don't settle, sit across the table and settle, what is the alternative for them? Go to court. Court will order an auction, ultimately. And you know in what happens court auctions? You will never get the real price. So therefore, when you tell them, look, what is being offered to here to you here versus what you will get in court, which is a better option. If that alternative is not a good alternative, take it. What you are being given here, negotiate, sit down, negotiate with that buyer, negotiate with your brother across the table and get the better deal. If we are alternate, that is why what we call, the two words you will find used, which we'll talk about a little later, is Batna and Watna. Now, Batna and Watna Batna is called better alternative to a negotiated agreement. And Watna is worst alternative to a negotiated agreement. If what I am getting here is better than what I'll get in court, it's my Batna. If what I am getting here is worse than what I'll get in court, then I would rather use this opportunity instead of going back to court. Because court is not a good alternative for me. So alternatives are always judged if whatever you are being offered here versus what you can get in court. Right? So, these all are used when you are negotiating. If parties get stuck on positions, that is what positional bargaining is. No, I want this much money. You tell them. If you don't take the offer, like, in that 1 crore 25, man wants 1 crore 25. Fellow says, actually, the market value is 1 crore. And he says, fine, to settle, I'm willing to give you 1 crore 5 lakhs. Now, the man still says, no, I want 125. So the way to test what his position is, this is something which we call reality testing also. Tell him, if you go to court, if the property is auctioned, how much will you get? And then there will be a receiver, then it will be a depressed sale. So many things, cost involved, lawyers' fees. You see, all this is shrinking the pie. That property value is shrinking by going to court. Your lawyer's fees, the court fees, time spent. But when you negotiate, you enlarge the pie. You may look at alternatives like, options like going to a builder, rebuilding the property, and you add value to that pie. You enlarge the pie. Something, the litigation shrinks the pie. Litigation will always shrink the pie. Out of that 100% which is available, it may become 90%. 10% will go to the lawyer, court fees, time spent, the expenses spent in court. So therefore, we need to look at communication, relationship, interest, option, legitimacy, alternatives. And the last one, last C is commitment. See, sometimes parties agree because there is pressure of litigation or they are expecting a wrong order to be passed by the judge. They will agree, fine, I'll pay you this amount, 50% now and the rest in 6 months. But the man knows heart of hearts that I'll not be able to pay in 6 months because I don't have the resources. But he will agree just to get rid of this litigation. And therefore, you have to ensure once even you reach that stage of settlement is the commitment of the parties to accept that settlement, to live with that settlement and to honor that settlement. And that's why don't rush into a settlement merely because the settlement has happened. Make sure that parties are really going to be committed to what they agree. They must be in a position to honor it. Your agreement should be, you should plan all the terms, the manner in which it is going to be implemented. And after these 7 elements, whenever you are negotiating, sometimes you'll find that, you are stuck, you don't know how to move. That's the time for you to remember, have I dealt with communication issues? Have I dealt with relationship issues? Have I looked at the interests of the parties? Have I explored all the options? Have I tested legitimacy? Have I asked the parties to look at alternatives? And are the parties really committed to settle? And to the settlement finally, which may be arrived at. Yes or no?
Note this about commitment that he will pay 6 months down the line. Can we ask for the bank statements?
Which
Are we
is
allowed to?
again, Sonu, you are judging. You
No,
don't
but
know.
he may not have
You don't
money.
know. You know, that's the time. You see, now, instead of asking for a bank statement, what is the question that you can ask? Now, let's fine. I appreciate now what you're saying. You want to weigh that actually the party is really committed. You have explored those, what is the question that you'll ask?
How are you going to pay, and how are you going to manage the finances is a direct question that can be asked sometimes.
Instead of how are you going, have you considered all your bank resources? Have you considered the monies that will come to you? Help me understand. You see, the questions when you in negotiation and mediation are listening for purposes of understanding. So paraphrase every one of your questions with, help me understand. Have you considered this? You know, they soften, otherwise they look like cross-examination. That you're not trusting the man if you ask him, no, have you looked at your accounts? Will you be in a position to pay it? Which means what? I'm not trusting that he will be in a position to pay that money, right? I mean, that's what the person will feel, no? So what you need to tell him is, help me understand, have you considered all your financial positions as you're making this commitment here? Do you think you will be in a position to, carry it through? You will be able to live with it? Whole purpose of negotiation and mediation is to keep people out of court. And in case if there is a default, you'll go back to the court. The other party will file execution of this settlement. So you're back in court. So therefore, commitment questions are, have we considered this? So that you don't, I mean, you can say now, see, that is what I'm saying. Curious question is, sir, I'm trying to help you to see that you don't go back to court. Would you like to help me understand? Have you considered all your financial positions before making this commitment? So your questioning skills will become different. You will say the same thing, but in a different way, which should look like empathetic. I'm trying to put myself into your shoes to understand. Empathy plays a very, very strong, role in negotiation or in mediation. That's the only, as I said, remember, not the content, but the context. And the only way you can come to know about the context from where parties come, if you understand from where they are coming. And that is all empathy is about. Why is that person here today? What is troubling him? Where is he coming from? How can he be helped? All these questions are empathetic questions. And if you keep them in mind all the time, when parties take position, empathy, why is he saying so? What is important to him? Why is it that important to him? But then you need to get those interests out. Therefore, you ask those questions. Help me understand why this is important. Help me understand what is important to you. So if you paraphrase with help me understand, you'll never go wrong. Or I'm curious to know. How will you do it? See? Okay, so these are 7 elements we need to keep in mind for purposes of every negotiation, because every negotiation has these 7 elements. Let's look at the next slide.
We'll look at barriers to negotiation next. And we have several barriers to negotiation. One of them is strategic barriers. We have principal and agent barriers, cognitive or perceptive barriers, and psychological barriers. Strategic barriers relate to decisions that the parties have taken to strategize the way they will approach a dispute. Many times you will have parties who will look at mediation as a way to perhaps delay their own commitment. They will say, there's a recovery case, for example, money has to be paid, and they are not in a position to pay that money, or they are not interested in paying that money in that period at that time, and they will actually use mediation as a strategy to delay the process. Exploring and understanding this is very important for a mediator. I can give you an example of a case that I was doing today itself, where the party did not appear for 2 consecutive sessions, and the lawyer basically kept asking for time, and said that my party is busy here and there and whatever. So I had a private session with the lawyer, and I asked him, let me understand from you what is going on here. Is there a real challenge, or is it, is there a delay that what I see is this could be a delay tactic, and I'm not comfortable with that. I want to understand from you. And we had a discussion, and he said the next time I will either come with a proposal, and I will explore this with my party, and I will come with a proposal, or I will, basically see that the party is present. If not, I will communicate to you that I will end this mediation. So recognizing a strategic barrier and addressing it is really important. The second, one more example could be where the party has chosen a legal route which has worsened the negotiation rather than, has basically brought in problems in the trust issue, such as matrimonial disputes. It's a simple matrimonial case, but the wife has gone and filed cases under 498A, which have a lot of false allegations. When such a thing happens, the relationship becomes more strained, and there are trust issues that develop. To explore that with the parties as to why that was done, it was as advised, that was the way that I could get faster relief. This is what I eventually wanted, and that's why I did this. To explore that and make the other party understand that while the allegations were false, they were something that the other party had no option but to take that route. So that's called strategic barrier that you will face, which will make communication and negotiation between parties difficult. To work through that and to be able to bridge that gap between parties is very important for the mediator. Then there are principal and agent barriers. Several times you will have parties who will send their lawyer to the table, or you will have a corporate entity that's represented by one of their employees, and that employee may not have all the powers, and they may keep saying that I'm going back and coming back with a decision. Now that becomes a major barrier, because mediation is not just about decision making. It's also about exploring facts, understanding interests, understanding the deeper reasons why the conflict exists. And an agent may not be in a position to help us with that. They will only come with certain instructions that they will communicate. And therefore, it will boil down to negotiation, to bargaining, and not really be able to explore deeper interests. So if you notice something like that, please make it a point to explore calling the real decision makers to the table. I've done that in cases, and once they come to the table, it is much easier to negotiate. This, of course, may not be a possibility when the organization is very large, but then you have to find ways to be able to explore the interests in such matters and understand that we are facing what we call as a principal and agent barrier. Then there are cognitive or perceptive barriers. And let me give you some examples. So supposing you own an apartment somewhere and you put a value to that apartment. Many times when we own an object, we put a value that is of much higher than what somebody else will put to it. That's called endowment effect. So if it belongs to me, I will put a value to it which is higher than what somebody else who wants to buy it from me will put a value at. And that's a bias that exists in many of us and can be a barrier to negotiation. Recognizing this bias and exploring it by certain criteria, just the way JP mentioned about finding out from the sub-registrar what were the last few transactions of a property of that nature in that area and what is the going price of that, is one of the ways to break that barrier and come to a reality. Then there is risk aversion. Risk aversion is when we we do not want to take a risk. We avoid risk at all costs. And that's also a barrier when you are exploring a solution or exploring a problem. So understanding that somebody may only jump into a resolution because they want to avoid going to court. And that may not really give them the kind of settlement that they're looking for, and actually create a power imbalance to be able to talk to that person and explain from where they're coming when it comes to offering a settlement or accepting a settlement is something that the mediator has to do. Remember one thing, a mediator doesn't just reach a settlement, help the parties reach a settlement. A mediator helps the parties reach a settlement that works for them. And therefore, if the settlement is being proposed or is being entered into because of a cognitive bias, it may not be a long-term solution. It may be something the parties may regret. And therefore, exploring that and trying to find a solution that will actually work in the long term is really important. And therefore, recognizing where is it coming from.
Chanda, can I just add here for a minute?
Yes, please.
You see, these two barriers are very, very well explained. Let me tell you with one particular very simple example. And this helps you actually to test when parties are sticking to positions, not moving towards interest, whether they are stuck on these barriers and where you can use this to shift parties from those situations. See, let's say, I'll give you I play a game that all of you, if you go through this door on the east, let's say we are sitting in a room, all of you who go through the door on the east, right, will get 1,000 rupees. And in case we will select one of you out of you who will have to pay 10,000 rupees. See, one is everybody else who goes out of this room will not have to pay through the east door. And I will select out of the 10 people, one person who will have to pay 10,000. Then the other game is everyone who goes through this room, the west door, will get 1,000 rupees. And select few, like we'll as we did there, we select one person who will not get any money. Which is the door that you will use, the east door or the west door? Here you get to pay, one person will play. Here everyone pays on the right door. East door, I select one person who will pay 10,000. On the west door, everyone pays who goes through that door will pay 1,000. Which door will you choose first? Let's look at this and then I'll come to the next one.
Would probably choose the west one where you have to pay 1,000 and go.
Why would you not choose the left one where you may escape?
I
Because
might be the lucky one sharing a lot of money then, giving 10,000 for going out.
You see, mostly people will prefer the east door because here, people will gamble for a loss. If there's a certain loss, I will gamble to avoid the loss. I'll take that chance. Right? But if the game was the other way around, that only one person gets 10,000 rupees, while on the other door, the west door, everybody who goes out will get 1,000. If only one person will get 10,000 from the left east door, but everyone who goes out of the west door will get 1,000. Which door would you use? East door, only one person will get 10,000. But on the west door, everyone gets 1,000. Here it's 10,000. You may not get anything. Which door will you use?
The
to
west
go?
door.
The right door, because you don't gamble for a gain. You gamble to avoid a loss. That's psychological, but you will not gamble. That's why, we said a bird in hand is worth, two in a bush. When we tell parties, look, if you go to court, you may get a decree, but you may not get your money. That 2 lakhs that the other person owes you. But look at this now situation where a man is willing to give you 1 lakh today and says, well, I'll give you the rest in installments. Or against 2 lakhs, the man is willing to pay you 1,50,000 and says, look, I can only afford this much. Versus in a decree in court after 7 years, which I may not be able to execute. Which one would you go for? I mean, your principal is 2 lakhs. The man says, I'm willing to pay you 1,50,000. Of course, you feel cheated because you're getting something less. But that versus court decree 7 years down the line, which you may not be able to execute, the person who owes you money may not have the assets available.
I'll go for 1.5.
1.5, because you will not get, this is a sure gain. This is the reason why settlements happen in negotiation. Because you do not wish to gamble for gain, you will gamble for a sure loss. And this is what cognitive barrier is about. That's one way I thought the Ganda, this is a simple example. I thought let me just put it this way. Because people don't gamble for a loss. That is why they settle. They will go for a sure gain versus a gamble. What is a gamble? You don't know whether you will win or lose. Consumer case, you have filed, the other side has filed. You see, this is why, what are you doing? Like, let's say the doctor's example. A man files a consumer court complaint. Likelihood of gaining, when will that happen? District Commission, State Commission, National Commission, Supreme Court. Right? And how much compensation will be paid? God only knows. Versus the doctor saying, fine, I don't want to go through this harassment, though I don't admit the guilt, let's say the complaint is for 10 lakhs, take 3 lakhs, finish it. Lawyers' fees in district court, State Commission, the NCRDC, National Commission, then the SLP. How much money that man will spend? This is why settlements happen. Because people will go in for a sure gain, will not gamble for a gain, but will gamble for a loss. They are willing to give up, which is a gamble in court versus what they are getting here. Does it make sense now? Okay, Kanda.
Yes, and I'll add a little more. There's also the assimilation bias and reactive and unintentional blindness. Many times when we know we have a case, we tend to focus only on the parts that are favoring us. We say we have a very good case. If we go to court, we will win. When we say that, many times we don't consider what it will cost us to go to court. And the fact that, it's never a, like JP said, it's not always a sure shot. It's a gamble. The number of judgments you will find in your favor, you will find a few judgments against you. The idea is for you to explore as a mediator, where is this coming from? And are you really sure about what you're going? So this gamble has to be brought out during the conversations. And it's when they see the gamble, they realize, okay, no, this is not a sure shot. I have a case, but I may or may not win. And that's the time they start looking at settlements. And there's also a very important thing for mediators. It's called reactive devaluation. Many times offers that are offered by the other party, are devalued just because they are making the offer. This is a pattern that you will start noticing during the mediation, that if something comes from, for example, in a matrimonial matter, and there's a maintenance issue, and the husband says, okay, I will pay you 40,000 rupees per month. Because it's come from the husband and it's come as an easy offer, it will immediately be rejected, because the feeling is, oh, he's giving it so easily, that means he can afford more. You may not have the entire idea. So you're saying, no, I'm not going to accept it because he's giving it to very easily. I'm going to, ask for a lakh of rupees. Now that may or may not be the reality. Then exploring what is your real need. Where are you coming from? What do you think his income is? Have you looked at his, income tax returns? What is it will happen if you go to court? Questions such as these will help you come to that reality. And we also sometimes use a technique called changing the messenger, where the mediator steps in and makes an offer. And of course, this is done in, really those circumstances where you see that absolutely no offers across are being accepted. And it's basically because the individual who's making the offer, there's a cognitive bias against that offer because it's coming from that individual. So in such circumstances, the mediator can make an offer, and that may work better in some situations. So just understanding and really observing as to where this is going and where are we getting stuck. That's what we explore and try to meet ends there. So
Ganga,
that's
one more addition to
Yes,
just what
sure.
you said. When you said that the source is changed, right? And the mediator comes in at the last stage when we feel that nothing is moving. You know what you can do, another thing that you can do here, which is also called shuttle diplomacy.
Yes.
What does the mediator do? Ask the party as to what is good for you. The parties have their own perception of, I need a lakh of rupees, I need a 50,000 rupees per month or whatever. Ask that party, have you thought about it? What are your needs? That when 50,000 is the figure that you're giving me, help me understand as to how you arrived at that figure. You've done all that exercise. And when you go to the other side, let's say he says 50 and the other side says, okay, you also ask that other side, how much are you willing to give? So the person says 40. Messenger is changed, as Ganda said. Information is not going directly, but it's going through the mediator now. So mediator first, why is it called shuttle? Because first he goes to the wife, finds out as to what the wife wants. Then he goes to the husband, finds out as to what the husband is willing to give. Now he has both the information. So one is 50, the other is 40, right? Now he goes back to the wife. And this is where he uses diplomacy. And therefore shuttle diplomacy. And the diplomacy is, he goes and says, not that the husband has agreed to pay 40, but what if the husband is willing to give 40? Are you willing? Do you think that will help you, settle this dispute? So what Ganda said has done, that reactive devaluation, instead of the offer coming directly from the husband, is coming through the mediator, but it is coming as like a diplomat, not saying that the husband has agreed to 40, but what if the husband agrees to 40, do you think this will meet your need? Then the party will evaluate it for herself. If 40 is a good figure, she will accept it. But take it for granted, if it had come from the husband, as Gandha says, she says if he's agreeing to 40, therefore he's capable of paying more. She'll never agree to 40. So you here can play the role of a diplomat. And this is why we also use the word shuttle diplomacy. Yes, Gandha.
Yeah, next slide, Mrinalini. So we have discussed this today also, and we discussed this the other day. In this role play, just keep it in mind while we go ahead with our next session. Remember that bottle of water, and Vrushali and Dr. Subodh had done that role play where one needed the bottle, one needed the water, and how that negotiation happened. Let's look at let's look at the theory and then try and understand it with the help of this example. Also with the orange example that JP gave. Yes, next slide. So every case will involve parties, issues, positions, and interests. So when we as mediators look into a case, we must understand, first of all, whether the parties to the dispute are at the table or not. So like I said, sometimes there might be agents, sometimes you will have somebody from the company but may not have an authority to, may not have the entire vision of understanding the conflict. So it's important that the people who are there at the table negotiating and in the mediation are parties to the dispute, in the sense that they understand the dispute and they are also decision makers in the dispute. So ensuring that issues are the problems that are there between the parties. So trying, when you explore through communication and through the introduction phase and the communication, you will come to the point where you will understand, okay, these are the primary problems between the parties. These are the issues. This is where there is contention, which is both parties want different things. And they'll also have positions and interests. Positions are what stand the parties initially take, and interest is why they take them. Next slide. So the position will be generally the proposal, solution, and it will be one solution. So when the parties come to you, they'll say something to the tune of, see, we have this problem. I have a dispute with my brother, I have a dispute with this professional, and if I'm given so much money, this is the solution. I'm coming to you to negotiate and get this solution. The interest is the motivation, hope, desire, need, worry behind the solution. Why they want that solution is the interest. Position is what we decided upon, and interest is what caused us to decide upon it. Surface statements, which rarely provide much insight, are positions, and insightful observations on the underlying values and motivations are interests. Demands are positions, concerns, aspirations, fears, motivations are interests. Subjective wants are positions, objective needs are interests. When we focus on positions, it leads to positional bargaining, because there's one solution to the problem, and either I get what I want or I lose. So that is positional bargaining. When we focus on interests, it helps us collaborate, and it leads us to something that we call integrative negotiation or collaborative negotiation. Now let's go back to the example of the bottle of water. Would you all like to tell us what was the positions in that case and what were the interests?
Position was I need the bottle of
Bottle of water. Yes. And what was the interest?
interest of Dr. Subodh was that he needs a spare bottle in
Mhm.
case he gets thirsty on the way, on the journey. Ushali had the interest that she's dehydrated and there may be a medical emergency if she doesn't have water immediately.
Yes. So she needed the water. And if you understood the interest, you could actually distribute what each one wanted at that point in time. Let's go to the other case that we looked at, the builder case. Can we have a understanding on what was the position and interest there? Was there, first of all, positions and interests in that case, and what were they, if at all?
Position was he won the flat.
Possession of the flat immediately.
Yeah.
Yeah. That was the
And,
position. And what was the, now both parties have positions. What was the
position of the builder is that there is a delay due to unavoidable circumstances.
Yes.
So he cannot give the position back.
So we were stuck. We were stuck in a place where you couldn't proceed. And there was an offer which was not being accepted. What was the interest?
The interest of the yeah.
Son's- I'm sorry.
Yes.
Please go ahead.
The son's school should be in that 7-kilometer radius of the residence. So that was the main interest.
That was the main interest of the buyer. There was also an interest of the builder to
Not
settle
lose
the
his,
case.
to not lose his name and fame.
Yes.
Yeah.
Not it's so that it doesn't become public, not lose his reputation. That was important to him. So those are the interests. Now it's very interesting. I don't know what settlements you all reached that day and whether you all did. But this is a case that it's a real case in the Maharashtra Maharera that went on. And in fact, it got settled. This was the exact case. Of course, I've put a little masala in terms of place and stuff, but the facts were broadly the same. And apparently what happened at that point in time, and this is recorded by the RERA authorities, is that they shared with the builder in the session that, you know, the reason we want the flat is we need the address for admission. And apparently the builder was a very well-connected person. So he picks up his mobile phone and he dials a number and he says, this child needs admission. And I vouch for the fact that this is his residential address. It will be delayed for a little bit. But if, you know, on my recommendation, it can be accepted, I will give an affidavit that this is the address. And can this go through? And apparently it went through. So the primary interest was satisfied and there was no other need for settlement. Because the money as such was not really the issue. That the parents didn't want money. They wanted the child to get admission. So this is a real case that was recorded. And this is how, when you go down to really understand what the problem is, sometimes it's not what's visible on the surface. Because when you see it, you might think, they just want more money. They want to be compensated for that, you know, the delay in possession. That's what's happening. But the reason may be completely different. So when we are curious and we understand, sometimes really beautiful solutions can be reached. So that's how positions and interests work, and that's how mediation. These are really important components in a mediation. Next slide.
You see, you know, we've been talking about interests, right? Interests are sometimes, you know, our desires, our wants, things that move us to take positions. actual real movers behind why parties take positions. Now, there is another theory which is called PIN pyramid, or PIN stands for, now again an acronym, positions, I stands for interests, and N stands for needs. Now, positions we have understood are the stands taken on an issue by a conflicting party. Now, that stance will be based on an underlying interest. Correct? Why people take stands or positions is because of those underlying interests which move them. I want the orange. I want the water bottle. Right? But the core interests or core issues in which those interests are embedded are called needs. Now, needs are defined as goals which are pursued by an individual or a group in order to survive. In that sense, our needs are non-negotiable, because if it is a question of survival, I will not negotiate my needs. Let's see the next slide. So we said positions are something one decides upon. Interests are what causes one to decide. And interest defines our concerns, our needs, our desires, our fears, our hopes. Therefore, I said, when interests are rooted in the core issue, they are called needs. Interests motivate people. They are silent movers behind that position. Let's see the next slide. The PIN model says positions are at the top, the tip of the pyramid, what we say we want. Then the next are our interests, what we really want. See, that's why the question, what is important to you? Why is it important? So I want this. Why I want this is my interest, what we really want. And at the bottom of the pyramid are our needs, what we must have. You know, the most powerful human needs are 5. Security, something which I'm not willing to negotiate. If it comes to my security, is personal security, it can be emotional security. Second, economic well-being. See, if this maintenance does not meet my daily needs, I'm not willing to negotiate. So, first important aspect of human need is security. Second is economic well-being. Third, a sense of belonging. Belonging to a particular, society, particular religion, particular caste, particular area, in being Indian. You know, when we are abroad, being an Indian is a big thing. But when we are in Bengali, when we are in Maharashtra, my recognition or, belonging becomes Maharashtrian. I'm a Marathi. So this sense of belonging is very important. Then recognition. The fourth important human need is recognition. I must be recognized for what I do, what I stand for. That's why when you saw that, when we talked about that example, when you come home, the food is cooked good or bad, or the woman of the house has worked the whole day, or the mother has worked the whole day to prepare that food, so she needs recognition for something done. That is a human need. that I must be recognized for something which I do. And the last one is control on one's life, autonomy. Remember the SCARF model of certainty and autonomy? So these are my human needs. These are not negotiable, what I must have. So remember, when negotiations are happening, people will not give up these. And therefore, you have to, so positions, to shift parties from positions to interests, asking questions, and from interests going to their needs. What is the bottom line? And usually people are told never take a bottom line when you are negotiating. And sometimes, to distinguish between interests and needs becomes very difficult. Especially, in that example of the layers of an onion, when relationship is good, the layers are quite close together, and it's easy to shift parties from positions to their needs. But when they are in a conflict situation, these layers thicken and positions hide their needs when they are in a conflict situation. And it becomes difficult to reach to the core. And this is where your listening skills. See, when I told you about adding value in negotiation, the best way you can add value in negotiation is by building trust. When parties trust you see, because why are they in conflict? Because they don't trust the opposite side. Once you restore that trust, parties open up. That is where value additions happen. That is where they will tell you their interests. And that is where, when you know the interests, when you know the competing interests, when you know the common interests, that negotiation and finding solution to the problem becomes easier. So one of the ways of adding value in every negotiation is to build trust, because trust, develops, it comes from building of relationship. And that's where relationship becomes important. Dealing with relationship in negotiation. We told you about the 7 elements. All this is interlinked. So we need to get people from their positions to their interests, and if we can, within our means of questioning skills, reach their real needs. Then only negotiations become successful. Then only the problem solving happens. And sometimes people really do not realize, why do they take positions? And this is where you help them to shift from positions to their interests. Once the interests are on the table, then negotiation becomes problem, and problem solving becomes easier. Let's see the next. So therefore, positions, interests, and needs. Now, question is how to find interests. Now, we told you a few questions, the kind of questions that you can ask. Now, look at the questions that you can use. Why do you say that? Understand the reason behind the position. Why do you say that? Why do you want the water bottle? Why do you want the orange? Never, never, never in any negotiation or any relationship take positions for granted. Never, never, start negotiating at the stage of positions. Because sometimes negotiating at the stage of positions can give you the desired result, but it may not be a wise decision. People may not, ultimately that may not be fair to both the sides. Parties sometimes. So positional bargaining can give you results, but they are not wise. So always, whenever somebody tells you, and you may know the solution, but always start asking in every conversation that you do, when people come and take stands or positions, is why do you say that? What is behind it? Why is that important to you? What is important? These are very, very important questions which will, actually improve your communication skills. Now, so therefore, further clarificatory questions, funnel approach. Explore further using questions such as, after you have that one answer, unlayering of the onion. What are your concerns, worries, frustrations about that? What do you fear might happen if that happens? If that is given or that is not given to you? What do you hope will happen if you get that? Partnerships, when they break up, I want this client. Why this client? Why is that client important to you? Or I want the office space. Yeah, I mean, all these issues will arise. Question is, how do we, when parties take positions, how do we shift them? How do we get them from their positions to interest to their needs? What do you really care about? What is important to you about that? What will your solution help you accomplish? What leads you to believe that a solution will get at what you need? See, these are very, very beautiful questions. And let me tell you, when matters get resolved, Ganda would have experienced that many times. Parties come and thank you. And what do you say? I did nothing. You people found solution to the whole problem. I only helped you. I did not solve your problem. You only solved it. But why did that problem get solved? Because of realization. Because we helped the parties to shift from the positions which they took to their needs, and when they realize what their needs are. See, that is why sometimes, when somebody said this win-win, when you say about in a negotiation of a solution, that's a myth. Because really a person is giving up something. So how is it a win-win? Because he's losing something to gain something. But it is win-win because whatever he gets is satisfying his need, which is non-negotiable. Which if he gets, he is satisfied. Now, does it make a little bit, I mean, from where we started and where we are, does this sound now, taking you towards somehow conflicts resolution works? You think it's making sense? Because most of us actually negotiate at the level of positions. When a person says something that he wants, and then I see whether do I have the resources to give it or not, but I really do not ask the question why. You've seen, like, let's go and have Chinese. The question is, I want to have Indian. And then there is a fight. Should we have Indian or should we have Chinese? But do we ask the question, why Chinese and why Indian? Never. Most of our conversation is, nahi, aaj ye nahi khayenge wo. Like, we'll not see this movie, we'll see that movie. We'll not go for a holiday here, but we'll go there. Because we are only doing negotiation at the level of positions. Every statement that is made between, whenever we are in a conflict situation or negotiating, see, negotiation is a part of life. Let's accept it. We negotiate where we'll eat. We negotiate which holiday, when will we go for a holiday? Where will we go for a holiday? Should we buy a car or should we not buy a car? Will we be able to afford a car today or not? All these are negotiations, which we do. What did I tell you? Why do negotiations happen? Things that you can't do on your own, or when you are in a conflict situation, how to solve that problem. These are the two reasons why we negotiate. But question is, do we know how to negotiate? Do we add a value in every conversation that we do, negotiation that we do? And therefore, these questions are mantra for any constructive communication to happen. Because do not start your negotiation at the stage of position, because positions are really at the top of the iceberg, top of the pyramid. Those are things which you see. There are things which are underlying which you don't see. And that is where you need to get at. Then you'll get wise solutions. Let's see the next.
So JP, we can stop here for today
Okay.
and take questions and continue later. Any questions? So, by the way, the entire theory part of this is already shared with you in the manual. So, most of these, in terms of the points and the explanations, are there in the manual. There was a manual that was sent to you on day 1 when you all got the welcome mail. It's called the Mediation Training Manual of India. So you'll have it attached to that email. In case you don't find it, you can reach out to us and we'll send it to you again. So everything point-wise is already given and we are basically following that structure. Of course, the examples and all that, you will have to listen to the video. But otherwise, the points are explained there. So if there's, if you would like to read about it, that's a good place to go. And you can always come back to us with questions.
There was a psychological barrier to negotiation also, as one of the barriers you mentioned.
Yes.
So that is what?
That is what JP had explained about the.
Ganda explained to you what is called reactive devaluation. You don't trust the source. That's a psychological barrier because it comes from the other side. So you don't trust the source because you don't trust that party. So therefore, psychologically, any offer coming from the other side, you will outrightly reject. So remove that barrier. She told you, you change the messenger. The offer, instead of coming from the party, comes through the mediator. And mediator uses shuttle diplomacy.
Basically, it relates to, like this example, it relates to the assumptions that we make about the other party. And how those assumptions make us believe that the offers that are coming or the statements that are coming, there's something to doubt about that. So those are, you can never see things the way they are said. There is a lot of history behind in your relationship that makes you believe something else. And it's very difficult at that point of time for you to just accept what the other person is saying. Those are psychological barriers. Which we need to explore through various ways, questioning, going deeper, going into facts, sometimes documents, whatever may be required to clarify that statement or that message that is being passed across.
And in the pin pyramid is position and interest. So we have to get the interest basically. And after getting the interest, then do you dwell further and go into the needs also?
That's your skills. Sometimes at the stage of interest, the matters can get resolved. Once interest on the table, but sometimes parties still get stuck. So then you have to find out which is the need, which is not being met because of reason why the parties are still at that stage.
And they are those 5 needs what you spoke about.
Basic human needs are in the realm of those 5.
So you have to target only those 5 needs then.
I'm saying basically, they will be stuck somewhere in those 5 needs. I mean, that's what look, I always say, nobody certified me to be a trainer or a teacher. My knowledge is also based on certain theories which we were explained. which we have used in our, our basic, Ganda and my experience is the number of mediations that we've done. So we find practically, if parties are stuck even at that situation, you have to look at which are those 5 areas where they are not, which they are not able to get over. Because those are needs which they will never negotiate. Because they are non-negotiable. Because that's basically my survival depends on it. So I'm not going to negotiate that. If it's do or die.
But there might be other negotiable needs.
We can look at them. But certainly, mostly we see human beings, if you look at roti, kapda or makan, like, that's what generally they say. But look at what the 5 categories that I've told you. Security, economic need, recognition, affiliation, and autonomy or certainty. Now, these are things I cannot, you see, that's why I said when we do the opening statement, there's a very beautiful way you can put it. And you people did your opening statement very well. You can ask the parties, life decisions which you want to take, which are important to you. Do you like somebody else to take those decisions for you? They'll say no. So when you go to court, what do? Whether you should be in the matrimonial bond or not, whether you should have custody of the children or not, whether, what visitation should be. These are decisions which you should take, but what do? By going to the court, you leave it in the hands of the judge. Decisions which are important to you, you are leaving it in somebody's hand. Why don't you try your best and do your, sit down in mediation and get the best out of this opportunity that the court has given you. You can say
exactly
that.
Sorry.
You can say that Sonu in the opening statement itself.
Yeah.
You're lucky that you got this opportunity, like, to take decisions on your own.
So what is exactly the meaning of the 5th one? One's life autonomy. What does it mean? Or life's autonomy means? Certainty
of what your future should be. Your basic 5 domains. Then again, that is made on the David Koch, the model, that SCARF model. It basically is in all those, either your status is affected, your certainty is affected. Like, certainty, or how do you see your future events? Are you certain now? When people get married, they have certain ideas about what their future is going to be, and certainly that dream is shattered. You feel you're not in control of your future. Then decisions which should affect me, which I should take for myself, autonomy. Though they say there's nothing like absolute autonomy, because our autonomy is also conditioned by our social circumstances, society, the rules that the society has framed. That's why they call it relative autonomy. You can't be moved away from the society where you live in. You can't say I should behave in a manner which I want to do, because there are rules which prohibit you from doing certain things. So it's the relative autonomy, but autonomy still I need. What should I wear? Who should I sit with? Should I decide it in a particular way? Like, should I settle or not settle? That I should have the right to decide. Na? That much autonomy I need. And when those get threatened, people get into conflict.
I'm not sure whether the question I'm about to ask is relevant to the topic we are discussing, but maybe I will ask this question. Do insurance companies come on the negotiating table, or do they come for settlement? Because normally I've seen they carry the dispute up to the Supreme Court, because they have their own audit systems and they don't want to take the risk of one person settling the matter. Is there a vested interest, and all those issues come? So in your experience, do they really come on the settlement table?
Dr. Subodh, that is the problem. We got CVC in one of our initial trainings that we did in 2007. Only for this reason, because mostly in corporations or government, Nobody wants to take a decision. They want the court to take a final call and then pay kar denge. Let the court decide, I will pay. Because the man feels that if I take a decision, there is a monetary outflow. Before I retire, I'll get a memo and my retirement benefits will be stopped. But there are matters where government being on the other side, the largest matter that we've settled at the Delhi High Court was 570 crores. Where there was a government agency on the other side with a private organization, a public limited company. Settlements do happen. But yes, it is difficult. Insurance companies settle. You see, MSCT matters get settled. And that is why one of the reasons, when we were talking about healthcare industry, I was telling Ganda, we should also get insurance company on board. Because ultimately, somewhere insurance company is also going to be involved in all these damages, claims and malfeasance. Because doctors are insured. If you see this, funny thing, in America, you are insured for almost everything. And the largest buildings in New York belong to insurance companies. The tallest buildings are with the insurance companies. Insurance companies are involved, and in India, we need to sensitize them. And if they come onto the table, a lot of this litigation which lands up in court will ultimately get resolved outside court. See, because they know most of the times, like MSCT matters, they are clearly aware as to what are the parameters of an award and what are of the claim. That's spelled out in the act itself. They can evaluate for themselves. They have their own surveyors, they have their own evaluators. But question is, as you rightly said, that who will bell the cat?
So I want to add a little bit here. So Dr. Kapoor has been doing this for a while, and he has been in talks with insurance companies for which some companies have been involved where there's a cap that they have given for settlement. So if you are able to bring in a settlement within that cap, then the insurance company can fund that settlement. But beyond that, you have to go to court and get an order. So basically, that is, I think, some kind of agreement that they have reached, and he has an agreement with a group of insurance companies, which he uses for these kind of negotiations and mediations that are being done between doctor and patient. What he's hoping is that through this course and with more and more people becoming aware of mediation in the healthcare sector, the insurance companies are also brought on board, and we have a better understanding of this method, and then insurance companies can support. Because right now, there's always that little fear that what if the settlement is such where it's a agreement between the doctor and patient, and the insurance company loses. So therefore, there has been that whole understanding they're trying to build. But like you've rightly pointed out, without them being on board, this becomes a bit difficult for it to be a sustainable method. So I think Dr. Kapoor will be joining us sometime later this week. And when he does, he's very passionate about this subject, and also about the fact that how to bring insurance companies on board. We could have a small discussion on this topic with him.
In some of the discussions, we had said that in the opening statement, if there is a corporate or insurance company or something, then we need to see whether they are authorized to settle this matter. So,
Yes.
so if it's an insurance company, then what kind of authority do we look for? I mean, we ask for a power of attorney, or what kind of a document we look for, or do we simply verbally ask them?
Dr. Subodh, that's an area you can even ask for a letter of authority, just a letter from the board saying this man is authorized. But unfortunately, every time he'll say, I have to go back to the board. That's the problem. I mean, even if he has the authority to negotiate, he will not bind himself. He'll say, I have to go back to the board and get my formal permission. And that's why settlements, become difficult with corporations and government. They like to go to the highest authority to get the result, the actual approval. That's the problem. And this was asked by me when CEDR from London came to do a training for our judges here. By that time, this was maybe 20 years back. I mean, we started 16, 17 years back. So another 20 years back, they had already started. And I asked them, have you been able to bring the government onto the negotiating table? They said no. So even after 20 years then, at that time, they said we'll not be able to get them. And if you see the new act, the government has still left a lot of decision with them as to when they will bring, what kind of matters they will bring on the negotiating table, even under the new act. So that's the mindset, which needs to change somewhere. And that's why we got CVC. We said, lay down some guidelines so those people are not scared that you will, give them a memo and withhold their retirement benefits. But I don't think any guidelines have been laid down so far. That scare that, is always there. What will happen? Of course, there has to be some give and take, no? There will be some money going, you will give up something to get something. So the person feels scared that tomorrow, they will question me that because I think our mindset has become, I was talking about this to somebody in America. He said, it's not that corruption is not there, but corruption is not at that level, in a lower level, where people are totally honest in the sense, even if the president of US drives drunk and he's hauled up, he'll have to also spend a night at the police station, which an ordinary person would. I mean, there's no distinction created that. I mean, they may have corruption at a very high level, but here, unfortunately, we don't know where the buck stops. And ultimately, so that's the area where, but then you see, that's one part of conflict resolution. But as I said, we are not merely looking at conflict resolution of matters which are pending in courts. We are looking at also conflicts which arise between individuals and in the society, because that's where these skills will come in handy. Community mediations, at the level of community, at the level of neighborhood disputes. All these need deft handling. And that's why you need to have these skills. You have to impart these skills to your children as they grow up, so that they can handle, disputes on their own, these situations on their own. But unless you know them, see, that's why the problem with our children is because they don't have role models. And that's why the necessity to acquire these skills. And today we feel we so strongly feel, and when we are doing all this, idea being so that we can, create awareness, build capacity. So more and more people are in a position to resolve conflicts instead of every conflict landing up in court or in police stations or, getting into gundagardi on the street. Why can't we talk and resolve disputes? Why can't we communicate? I mean, this is what they said in Japan. When there's an accident on the road, both the sides, people will get off, bow to each other. They will, share their cards with each other and leave. Instead of here, if you see, the entire traffic will be stopped and the person will say, you don't know who I am. And there will be verbal duel, then they will be fighting with each other. Accident is an accident, right? Whether it's my fault, your fault, that the surveyor will see. And the insurance companies will take over. But here we fight. I mean, that's where we have not done that part. Person and problem get mixed up. Problem is the accident, but you are an irresponsible driver. License kahan se laye the? Do you know how to drive? I mean, that's the kind of argument which will happen. And you get into fisticuffs. that awareness is lacking. That's where we need to. But we need, I mean, it's really, I'm really thankful. I mean, you people, after your busy schedules, I mean, we were sometimes, we used to wonder how to get through to you people, like, with all your work schedules that you have, and then also to take out time in the evening. But the effort that you're making is commendable. It gives us hope that in the arena, the industry where you are working, people will look up, because they will trust you more than us. And that's where we wanted to break that ice by getting at least few doctors on board who will go and say, look, this is worth something. Whether it's personal relationship, whether it's workplace relationship. Ganda?
That's it for today. Thank you so much for joining us, for your questions, and we'll see you again tomorrow.
Ganda,
Thank
you're
you.
not looking well. Are you okay? You're looking quite down.
Yeah, I'm feeling a little not so good.
Yeah, you're looking under the weather. Take care. See you. Yeah.
Thank
Bye-bye.
you.
Take care then.
Good night.
Right.
Good night.
Bye.
Good night, sir.
Bye-bye.
Good night. Good night, sir. Thank you.
Good night. Bye-bye.
Good night.